Good day students, in this video we shall see about the state executive and the structure of the state government, how the sharing of the responsibilities happen between the various officers of the state executive, what are the minimum qualifications for entering the office of the state executives, and how the parliament are set up in the state. So just like we have a president who is the head of the union, we have a governor who is head of a given state. So the constitution clearly mentions that there shall be a governor for each state, provided that nothing in this article shall prevent the appointment of the same governor for two or more states, which means that the same person can be governor for two or more states. The executive power of the state is explained as below. The executive power of the state shall be vested in the governor, and it will be exercised by the governor either by directly or through officers who are subordinate to him in accordance with the norms of the constitution. However, nothing in this article shall be deemed to transfer to the governor any functions conferred by any existing law or any other authority, or prevent the parliament or the legislature of the state from conferring by-law functions on any authority subordinate to the governor. So, the states can give the authority to the governor in addition to this, and the governor shall be the agent of the president who shall exercise the duties of the president through the state government. So appointment of the governor. So governor of the state is appointed by the president by under his hand and seal. The term of office of a governor is defined as 5 years. So a governor, once he enters into the office, he can be a governor for that particular state for a period of 5 years from the date when he enters the office, and he shall hold the office as long as he enjoys the confidence of the president or as long as the pleasure of the president. The governor may, by writing a letter addressed to the president, resign from his office. It is the right of the governor that he can resign from his office. And however, under the provisions of the article, the governor shall hold office for a period of 5 years. There are certain minimum qualifications required to be the governor of a state. So first of all, he should be eligible for appointment. If a person has to be eligible to be appointed as the governor, then he should be the citizen of India. He should be citizen of India. And secondly, he should be above the age of 35 years. The minimum qualification is he should be citizen of India and he should be above the age of 35 years. The governor shall not be a member of either house of the parliament or of a house of the legislature of any state. If a member of house of parliament or house of a legislature is appointed as the governor, then he shall vacate his seat in that house by resigning on the date when he enters the office of the governor. Governor will not hold any other office of profit, and he will be entitled without payment of any rent or any amount to be eligible to avail the official residence of the governor and shall be entitled to such emoluments, allowances and privileges that are determined from time to time by Parliament by law. Whenever same person is appointed as a governor for two or more states, then the emoluments and allowances that are payable to the person shall be shared among the two states among which the person operates or is having authority as the governor, and it will be allocated among the states with discretion of the president. The emoluments and allowances of the governor will not be diminished during his tenure of office or during the time as long as he is in the office. The oath or affirmation by the governor. So every governor and every person who is discharging the functions of the governor shall, before entering the office of the governor, make and subscribe in the presence of the Chief Justice of the High Court, who is exercising the jurisdiction in that state. So for example, the High Court of Karnataka, the Chief Justice of Karnataka will be present and administer the oath to the Governor of Karnataka. Or in the absence of the Chief Justice of the High Court, a suitable person who is appointed, or the senior-most judge who is appointed for the High Court will be available. Discharge of functions of the governor in certain contingencies. So President can make the provisions as he thinks fit for the discharge of the functions of the governor of any state and in any contingency that is not provided in the chapter. The power of governor to grant pardons, etc., and to suspend, remit or commute any sentences in certain cases, just like president, is also applicable. However, the governor of the state has the power to grant pardons, reprieves, respites or remissions of punishment, or to suspend, remit or commute the sentences of any person who is convicted of any offence by offence against any law relating to the matter of that particular state only. So as long it is within the jurisdiction of that particular state, the governor has the right to suspend the offence against any person, the offence that is made against any law, and within the no, within the limits of the particular state, as long as the executive power of the state extends within that limits itself, he can pardon. Good day students, in this video we shall see about the state executive and the structure of the state government, how the sharing of the responsibilities happen between the various officers of the state executive, what are the minimum qualifications for entering the office of the state executives, and how the parliament are set up in the state. The chief minister and the council of ministers. So council of ministers will be present in order to aid the governor in administration. So there will be a council of ministers along with chief minister who will be the head of the council of ministers, and these council of ministers along with chief minister will aid and advise the governor in the exercise of his duties. The council will advise the governor in the administration of the state. If any question arises, if any question arises whether any matter is or is not a matter with respect to which the governor or under this constitution required to act in his discretion, the decision of the governor in his discretion will be final, and the validity of anything done by the governor will not be called in question on the ground that he ought or ought not have to be acted in his discretion. So the actions of the governor need not be explained to anyone. Governor will act on the advice of the ministers. And the question whether any or if so, what advice was tendered by the minister to the governor will not be inquired in any court of law. So whatever happens between the ministers and the governor will not be inquired. It is up to the two executives to decide on the administration of the state. Other provisions to the ministers. So chief minister, the provisions provided in the constitution to ministers and the chief ministers is explained as in. So the chief minister will be appointed by the governor, and the other ministers who are required to assist the governor and the chief minister in administration will be appointed by the governor on the advice of the chief minister. So it is the chief minister who will choose his cabinet, and the governor will choose the chief minister. The governor will choose the chief minister based on the support that he is having in the state legislature. So if he is having the majority support in the state legislature, such person will be chosen as the chief minister by the governor. Provided that in the states of Bihar, Madhya Pradesh, Orissa, there will be a minister in charge for tribal welfare. So in the states of Bihar, in states of Madhya Pradesh and states of Orissa, there will be one minister who will be in charge of the tribal welfare, and he, in addition, he will be also charge of the welfare of the scheduled castes and scheduled tribes and backward classes. There is a capping provided in the constitution on the number of ministers, including the chief minister, in the council of members. The number of ministers along with the chief ministers in the council of ministers will not exceed 15%. It will not exceed 15% of the total number of members in the legislative assembly of that state. Which means if the strength of the legislative assembly is 200, then the council of ministers will not exceed 30, which is 15% of 200. So this is the maximum capping on the maximum number. However, there is a capping on the minimum number also, which is given in the second clause. It states that provided that the number of ministers, including the chief minister in the state, will not be less than 12. So the minimum number is 12, and the maximum number of ministers that can be there in the state cabinet is equal to 15% of the strength of the state legislature. A minister for a period of 6 consecutive months is not a member of the legislature of the state, then he cannot continue as the minister. If a person is supposed to be minister of a particular portfolio, then he has to be member of the state legislature. So beyond 6 months, if he is not the member of the state legislature, he cannot continue as the minister of a given portfolio. The salaries and allowances of ministers will be decided by the legislature of the state and will be changed from time to time by law, and it will be determined from time to time by law by the legislature of the state, and this is mentioned in the second schedule of the constitution. The constitution of legislature in the states is also mentioned in the Constitution of India. For every state there shall be a legislature which shall consist of a governor, and for the states of Andhra Pradesh, Bihar, Karnataka, Maharashtra, Telangana and Uttar Pradesh, there will be two houses, that is the upper house and the lower house, just like Lok Sabha and Rajya Sabha at central government level. There will be a Vidhan Sabha and Vidhan Parishad at state government level. Whereas in other states there will be only one house. So for the states of Bihar, Andhra Pradesh, Karnataka, Maharashtra, Telangana and Uttar Pradesh, there will be a bicameral setup of legislature. Whereas for other states there will be only one house, which is a unicameral setup of legislature. So wherever there are two houses of legislature for a state, one shall be known as the Legislative Council and the other will be called as the Legislative Assembly. And wherever there is only one house, it will be called as the Legislative Assembly alone. The Vidhan Sabha, also known as the Legislative Assembly, is the lower house of the state legislature in India. The members of the Vidhan Sabha are direct representatives of the people of the state. Since they are directly elected by the electorate that consists of all the adult citizens of that particular state. So the members of the Vidhan Sabha or the members of the Legislative Assembly are directly elected by direct elections. The maximum size is outlined in the Constitution of India, and it should not be more than 500 members. So any state legislature should not have more than 500 members, and it should not be less than 60. Any state legislature should not have less than 60 members. However, there are exceptions. That is, the legislature of Goa, Sikkim and Mizoram. It has been approved by the Act of Parliament that the states of Goa, Sikkim and Mizoram can have less than 60 members in the Legislative Assembly. However, the governor can appoint one member to represent the Anglo-Indian community if he thinks that the community is not adequately represented in the House. And each Vidhan Sabha is formed for a period of 5 years term. So elections for the Vidhan Sabha or the Legislative Council happen for a term of 5 years, after which after 5 years term all the seats will be up for election. The house will be dissolved and the state will be up for election. Except in certain cases, that is during the state of emergency, its term may be extended beyond 5 years, or it may be dissolved. It can also be dissolved if motion of no confidence is passed within it against the majority party or the coalition. So under these two scenarios, the state can be the Vidhan Sabha can be dissolved. So the qualifications to become the member of the Legislative Assembly: the person has to be the citizen of India. He should not be less than 25 years of age, and he should be mentally sound. He should not be bankrupt. He should also be he should also stay in affidavit that there is no criminal procedures against him. So these are the qualifications for a person to enter the state legislative assembly. That is, he should be citizen of India. His age should be above 25 years. He should be mentally sound. The person should be mentally sound. The person should not be bankrupt. The person should not have any criminal procedures against him. The members of the Vidhan Sabha elect a speaker for the Vidhan Sabha, who will be responsible for the conduction of the business of the Vidhan Sabha, and also they will elect a deputy speaker who will preside in the absence of the speaker. The Vidhan Sabha will hold a equal legislative power with the upper house, that is the Vidhan Parishad, except for the money bills. For the money bills, Vidhan Sabha has the ultimate authority. Other than the money bills, for all other proceedings, it has equal power as per the legislature, as per the upper house. If conflicting legislation is enacted by both the houses, then joint sitting is called to resolve the differences. If a conflicting legislation is enacted, then a joint sitting will be called to resolve the differences. However, in such cases, in such a session of joint sitting, the members of Vidhan Sabha will generally prevail, because the members of Vidhan Sabha includes more than twice the members of the Vidhan Parishad. The members of Vidhan Sabha is normally more than twice the members of Vidhana Parishad. The powers and functions of the House. A motion of no confidence against the government can only be called in the Vidhan Sabha. A no confidence motion against the government of the state can only be called in the Vidhan Sabha. If it is passed by a majority of vote, then the Chief Minister and his Council of Ministers should collectively resign. A money bill can only be introduced in Vidhan Sabha, and after it is passed in the Vidhan Sabha, it is sent to the Vidhan Parishad, where it can be kept for a maximum of 14 days. Unless the Vidhan Parishad rejects it or 14 days lapse, or the suggestion made by the Vidhan Parishad are not acceptable to the Vidhan Sabha, the bill will be considered as passed. The budget for the state can be presented in Vidhan Sabha only, and it is presented by the finance minister of the state in the name of the governor of that state. In matters related to ordinary bills, after it is passed by the originating house, that is either Vidhan Sabha or Vidhan Parishad, it is sent to other house, where it can be kept for a maximum period of 6 months time. If other house rejects the bill or 6 months time passes by, or the suggestions made by other house is not acceptable to the originating house, then it results in a situation of deadlock. This is resolved by the governor by calling a joint session of both houses, which is presided by the Speaker of the Vidhana Sabha, and it is decided by a simple majority. Since Vidhan Sabha has greater number of numerical strength, it is in a position of advantage unless it is fractured by many different parties. The Legislative Council. The Vidhan Parishad is also known as the Legislative Council, and it forms part of the state's legislature. In 6 of India's 28 states, that is Uttar Pradesh, Bihar, Karnataka, Maharashtra, Telangana and Andhra Pradesh, the Legislative Council serves as the upper house. The Legislative Council will serve as the upper house of the bicameral legislature. It is a house indirectly elected by the people. It is also called as a permanent house because it cannot be dissolved, and only one-third of its members run for election once every 2 years. So every member of Legislative Council, that is an MLC, serves for a term of 6 years. The qualifications required by a person to be a member of Legislative Councils are as mentioned below. That is, he should be a citizen of India. He should be above the age of 30 years. He should be mentally sound and should not be bankrupt. And his name should appear in the voters list of that state from where he is contesting the elections. The size of the Vidhan Parishad cannot be more than one-third the size of the Vidhana Sabha, the legislative assembly or the lower house of the state, but its size cannot be less than 40 also. So the minimum size of the legislative council is 40 and the maximum size is one-third the size of the Vidhana Sabha. And 1/6 of its membership is nominated by the governor. The governor chooses the people who have done exemplary work in the fields of science, arts, social service and other activities, and he shall nominate 1/6 of the members from this list. And another 1/3 of the members are elected by the local government bodies, that is the local municipalities, corporations, and 1/12 by the teachers of secondary schools, colleges and universities.